Hi, everyone. Aaron Kolodny from White and Case on behalf of the Official Committee of Unsecured Creditors. Everyone will soon be receiving their ballot to cast a vote on the plan of reorganization. The debtors started sending out ballots this morning, and so I thought it'd be helpful to film this video to walk through the ballot so that everyone can make sure that they are casting an informed vote and know how to cast that vote on the plan of reorganization. So let me share my screen. You will soon be receiving an email from Stretto that looks just like this. I had them mock one up for me, and as an initial note, I will say that I am not a creditor of Celsius, and all of the amounts listed in this are fictitious but meant for explanation purposes only. When you receive this, there's two different parts. The first is the solicitation package, and I want to draw your attention to two different parts of that. The first is the disclosure statement. The disclosure statement in a Chapter 11 case is extremely important. And this is where you go if you have any questions on the plan and what the plan does. We recently had a hearing at which Judge Glenn approved this disclosure statement as containing adequate information for all creditors to cast an informed vote on the plan. Now, two really important parts of this disclosure statement. I think the first one are the table of contents. And Section 3 of the disclosure statement contains answers to commonly asked questions that both debtors in the committee believe creditors will ask, and also that creditors have already asked. So if you have a question about the disclosure statement, the plan, or anything else about the Chapter 11 cases, the first place I would go is to this list of questions. And I want to point out that the page numbers are the page numbers at the bottom of the page, not the PDF page number. As you can see here, I'm already on page 7, so it just wouldn't work to do it on the other way. The other thing I want to draw your attention to with respect to the disclosure statement is the preliminary statement. And here the debtors have done their best to describe these Chapter 11 cases and the plan in a manner in which is understandable to the average customer. So moving from the disclosure statement, the other item that I wanted to draw your attention to is the letter from the Official Committee of Unsecured Creditors. The plan was developed with a lot of input from my clients, the committee, and we fully support the plan and recommend that all creditors vote to accept the plan. We drafted a letter explaining our support and our recommendation to creditors. The first part of this explains why we think that creditors should vote to accept the plan. We've included the projected recoveries from the disclosure statement, and we've also included sections on the settlement of the committee's class claim against the debtors. And we believe that the settlement of that class claim will allow the debtors to return more coins to creditors faster by reducing the amount of reserves that are needed and reducing the amount that would otherwise have been spent litigating claims of creditors. It also describes the treatment between earn and borrow claims, which was arrived at through a mediation before Judge Wiles that was attended by the debtors, the committee, the earn ad hoc group, and the borrow ad hoc group. And finally, it talks about why we believe you should opt in and contribute your claims to the litigation trust rather than pursuing them on your own. So going back to the ballot or the email, once you have read the solicitation package, to cast your vote, you should click on the hyperlink, and you'll notice there's a pin right here, and this will take you to the Stretto landing page, and you enter your unique pin. And once you enter that pin, as you'll see, I have already walked through this, so you can click through that to get to your ballot. It takes you to your customized ballot. At the top of each page is a hyperlink to instructions to complete the ballot. So if you get lost, you can always click on this, and it will tell you what each item is and how to complete it. The first page contains a lot of important disclaimers, including the voting deadline, which is September 22nd, 2023, an important note on the class claim settlement, and some instructions for how to read your account holder ballot. Now, On the next page, the ballot is arranged in items. And item 1 lists your claims against the debtors. And now these are your scheduled claims, which are the amounts that you will be voting on the plan. As you can see at the top, it lists the cryptocurrency, the claim in cryptocurrency. So here I've got a Bitcoin. I've also got some Ethereum. And it also has, it lists your retail borrower deposit claim. So this deposit claim is the full amount supporting my loan. And then it lists the outstanding principal amount of your loan. And we'll talk about this a bit later, but the difference between your principal amount and the amount supporting your loan is referred to as your retail borrower post set-off claim. These are all of these numbers are in US dollars, which are calculated based off of cryptocurrency prices as of the petition date. Finally, item 1 shows your preference exposure at the bottom. So going on to item 2, this shows all of the different items that you should focus on for the various different claims, and that's what we're going to walk through next. So the first item is the treatment of retail borrower claims. Under the plan, retail borrowers have the option to either repay all or a part of their loan and receive an equal amount of Bitcoin or ETH. Now, the reason that this was negotiated by the borrower group is it may provide tax benefits to certain retail borrowers. And I am not able to give tax advice. I don't know people's individual tax position, but you should consult your tax advisor to see if this may benefit you. If you, we are not asking you to repay your loan at this time. If the plan is confirmed, we will send instructions to all retail borrowers how to effect this swap of repayment for Bitcoin or ETH. If you choose not to repay your loan, you won't have to repay it. Instead, you'll receive the set-off treatment. And now, under the set-off treatment, a borrower will not have to repay their loan. The amount of their outstanding principal obligation to the debtors will be subtracted from their retail deposit claim. And as I mentioned before, the remaining amount is referred to as their retail borrower post set-off claim. So in other words, you keep the money that the debtors provided to you as part of your loan, that's reduced from your claim, and then you have an amount of the excess, which is equal and is referred to as the retail borrower post set-off claim. Now, the treatment of the retail borrower post set-off claim is identical to that provided to earned creditors. In other words, a borrower will receive its pro rata share of Bitcoin and ETH, referred to as liquid cryptocurrency, NewCo stock, and litigation proceeds on account of this post set-off claim. One of the negotiated outcomes of the mediation is borrowers will get first priority with respect to an election, which is referred to as the liquid cryptocurrency weighted distribution election. I'll talk about that a bit more later, to receive only liquid crypto. Those elections are going to be given first priority over other earned creditors. And that, again, was part of the settlement that was negotiated with the borrower group. Moving to the next item, this describes the treatment for convenience claims. Convenience claims are any claims against the debtors that are greater than $10, but less than $5,000. And those claims will receive Bitcoin and ETH in an amount equal to 70% of the dollarized claim as of the petition date. Now, the next item also concerns the convenience class election. And this allows a creditor with a general earned claim, so a claim that is higher than $5,000, a withhold claim that's higher than $5,000, or a retail borrower post set-off claim to opt into the convenience class and receive the 70% in liquid cryptocurrency. The catch is to do so, you have to reduce your claim to the convenience class level. And so if you had a $6,000 general earned claim and made this election, you would have to reduce that $6,000 claim to $5,000, and then you would receive 70% of the reduced $5,000 claim. To make this election, you also have to vote in favor of the plan, And so if you check this box, it is going to be carried through to your vote on the plan, which I'll show you a little later. I'm going to uncheck it for now. Now, item 6 is what we referred to earlier, where a creditor can elect to receive more liquid crypto or more New Coast common stock. It's otherwise been called the Tony toggle. If you elect to receive more liquid crypto, you will do so at a 30% discount to the default election. If you elect to receive more New Coast stock, it will be at a 30% premium. And debtors have shown an example of that here. So as you can see, if you make no election, there's no change in your recovery percent. If you elect to receive common stock, you get a premium on the common stock, which results in a higher total recovery of approximately 8% under this example. Similarly, if you elect to receive more liquid cryptocurrency, you receive a lower total recovery, which will increase a discount, but you will receive more liquid cryptocurrency. Now, you don't have to make this election. You can simply receive the default treatment. If you do make the election, you click one of these. And again, to make the election, you have to vote to accept the plan. And so that will carry through to the acceptance. I'll note that the election is a trade between account holders. And so to the extent that you want more liquid crypto and you make this election, it will only be satisfied to the extent there is someone on the other side of that trade. And as I said before, retail borrowers are going to be given first priority. And so if there are a number of retail borrowers that all accept to receive liquid cryptocurrency, those will be filled first from those that elect to receive more NewCo common stock, and then we'll move to the earned claim. And to the extent it's not fully subscribed or there is an imbalance, the debtors are going to spread it pro rata so that we can honor as many people as possible. Now, I'll check to accept more NewCo common stock and move to the next ballot. So item 7 describes the custody claim. And this section incorporates the custody claim settlement, which was approved by the court last winter. Under the custody claim settlement, electing holders will receive a distribution of cryptocurrency equal to 72.5% of the amount of their claim in kind. So in other words, if you deposited 100 Bitcoins into custody, you would receive 72.5% or 72.5 Bitcoins back. Now, the reason why you're not receiving 100 Bitcoins back is because there are potential preference actions. And by electing to receive treatment A, you are agreeing to settle those preference actions with the debtors. If you already made the election to participate in the custody claim settlement, you are automatically treated to receive treatment A and deemed to vote to accept the plan. If you didn't make the election, but you want to now, you can do so by voting to accept the plan. If you don't want to accept the settlement, you should reject the plan or vote your custody claim to reject the plan, which I'll show you later. And this down here says how you should vote and where to vote in the ballot. Moving to the next item, item 8 concerns the class claim settlement. Earlier this year, the committee brought a class action claim against Celsius on behalf of all account holders, asserting damages related to, among other things, the pre-petition fraud, misrepresentations, and mismanagement by the debtors. Recently, we agreed with the debtors to settle that claim. Under the settlement, all account holders, other than account holders with custody claims, will receive a claim equal to 105% of their scheduled claim. And all account holders are able to opt out of that settlement by checking this box here. If you choose to opt out of the class claim settlement, your claim will be a disputed claim and you will not receive a distribution on the plan effective date. You will also have to prove your claim and establish an amount of damages before the bankruptcy court before a distribution can be made. The committee strongly encourages you not to opt out of the class claim settlement. But put simply, the more account holders that participate in the settlement, the less amounts the debtors will have to hold back on account of disputed claims. And that means that the more cryptocurrency that can be distributed on the effective date to all account holders. So we believe that this is an efficient and equitable way to resolve all claims against the debtors. And one more point, if you opt out of the class claim settlement, you also don't receive the 5% increase to your claim. And so if you believe that you have a claim against the debtors that will result in more than 5% and you want to pursue that, you can check this box. It will result in a delayed distribution to you. You'll have to prosecute that claim before the bankruptcy court, and you won't receive that 5% bump if you fail in establishing your claim. So again, the committee recommends that you do not opt out of the class claim settlement. So now turning to item 9, your vote on the plan. As you can see here, because I made the NewCo stock, the election to receive more NewCo common stock, this is defaulted to accept to vote the plan. And it explains in red why that election has been made. If you want to change that, you can use the navigation buttons at the bottom of the page to go back and undo your selection so you can move here and vote to accept or reject the plan. So if I were to do that, just to show everybody, I can unclick this and have the default. And then moving to 9, I now have the option to accept or reject the plan. So I select to accept the plan. And as you can see, you can't split your vote. So if you have borrow claims and general earn claims, you have to vote in one block, each one to accept the plan. The only exception to that is custody claims. And as we discussed before, if you want to opt into the custody settlement, you can vote to accept the plan. If you do not, you can vote to reject the plan. And you're able to do that independently for your custody claims so that you can choose whether you want to settle the avoidance actions or proceed with litigating those later on. Now, once you've cast your vote, the next item, item 10, details the releases under the plan. Unless you check the box to opt out of the releases, which is here, you will grant the releases set forth in the plan. And now these releases are incredibly important, and you should read them carefully and consult with an attorney to the extent you have any questions. Importantly, you are not able to opt out of the releases if you vote to accept the plan. So a vote to accept the plan is a vote to release, to grant the releases provided therein. Of importance, the releases expressly carve out excluded parties. And Stretto has included a link here where you can look to see the current list of all excluded parties. Now, this list is subject to change, but is available for everyone so that they can make an informed decision of whether to opt out of the releases. Item 11 concerns whether creditors should contribute their personal claims against third parties to the litigation trust. Now, there may be certain benefits to pursuing of the litigation trust or the litigation administrator, to pursue claims held by individuals rather than claims held by the debtors. Importantly, if you check this box to contribute your claims, any recovery that the litigation administrator receives on account of that claims will be distributed pro rata to all account holders. So the litigation administrator will not be pursuing that claim on your behalf and distributing money solely to you. Instead, he will be looking at the claims assigned to him as a whole and then pursuing those claims and distributing litigation proceeds as a general matter to all creditors entitled to receive those litigation proceeds. The committee encourages that you contribute your claims to litigation administrator and believes that pursuing claims against third parties in a collective manner will provide greater recoveries to account holders than otherwise would be provided if individual account holders were to pursue those entities on their own. Item 12 describes the account holder avoidance action settlement. Under that settlement, account holders who are not an excluded party, who have withdrawal preference exposure of under $100,000, who vote in favor of the plan, and who do not opt out of the releases under the plan, will receive a release of all avoidance actions against that account holder. Account holders who have withdrawal preference exposure of more than $100,000, who vote in favor of the plan, do not opt out of the releases, and who provide the debtors or the litigation administrator, as applicable, with the payment equal to 27.5% of their account holder withdrawal preference exposure no later than 14 days prior to the effective date will also receive a release of all avoidance actions. Now, on the ballot, there is a checkbox where you can indicate if you are interested in setting off a portion of your distribution to apply to the 27.5% payment instead of making a cash payment to the debtors. We've spoken with a bunch of account holders that are interested in doing this and thought that this indication would allow the debtors to reach out to those folks whenever the time comes to make the payment to explore if that's a possibility. If you're interested in exploring that, please check this box when filling out your ballot. Now you'll see at the bottom that there is a box that shows your withdrawal preference exposure. That amount and how the debtors calculated that amount is detailed on page 76 to 82 of the disclosure statement. So if you'd like to participate in the account holder avoidance action element, please make sure that you satisfy the requirements here, and then the debtors will contact you as we get closer to the effective date with information as to how to provide payment if you fall into the second bucket. Now, once you've completed your ballot, this is the certification. And so to submit your ballot, you have to type in your name. You've got to include your telephone number. And once you're done, you click submit. And now once you submit your ballot, you'll receive a reference number, which will be used, and you can contact Spreado if you want to confirm that your ballot was correctly submitted. Now, I just want to stress that the committee, the committee and the committee members especially have put in a lot of time and work formulating this plan. We truly believe that this is the best available alternative for the debtors at this moment. And we believe that all creditors should vote to accept this. These bankruptcy cases have been long, they've been contentious, and they've been difficult. And we really want to make sure that we're able to return as much value to creditors as soon as possible. And this plan is the best way to do that. So with that, I thank you all for joining me. I want to thank our committee members. I want to thank the debtors for putting this all together. And I strongly encourage all creditors to vote to accept the plan. Thank you very much.